The Honorable Court of Criminal Appeals of Tennessee is now in session.
Thank you. We're back in the April oral argument session of the court here in Middle Tennessee. Pardon me. Today's panel consists of, to my right, our excellent presiding judge, John Everett Williams. To my left, Judge Camille McMullen, also an excellent judge, by the way. And my name is Kerwood Witt. I am from Monroe County. Judge Williams is from Carroll County, and Judge McMullen is from Shelby County. Arguments today are 20 minutes aside. If the appellant wishes to reserve a portion of that time for rebuttal, the lawyers should make the announcement of that reserving time at the beginning of argument. Call our case, please.
State of Tennessee versus Angela Kilgore.
Thank you. Mr. Ridley.
Good afternoon, Your Honors. Todd Ridley on behalf of the appellant Angela Kilgore. If I could have 3 minutes for rebuttal.
3 minutes?
Yes, Your Honor.
All right, thank you.
Thank you. Again, good afternoon, Your Honors. Today we're here on the matter of State v. Angela Kilgore. And I know Your Honors are familiar with the briefs, and I'd like to start today by discussing the search and, most importantly, seizure of items from Ms. Kilgore's vehicle that occurred in Marion County. The issue that we're here today on regarding that search is that the officers who conducted it exceeded the scope of the warrant that was issued. This violated the statutory and rule-based guidance on how search warrants are meant to be executed. Because they exceeded the scope of the warrant and the directive that it had, the trial court erred when it denied the motion to suppress and allowed the state to proceed to trial using evidence that it obtained through that search and the testing that it did following its initial search. So the first part of the argument is relatively simple. What the warrant did, or what it commanded the officers to do, was to search a certain vehicle. What the officers did instead went far beyond that. What the officers did, instead of searching the vehicle that was identified in the warrant, was they went to that vehicle, gathered all of the things that were inside of it, took the truck itself, took the items inside of it, sent them to a lab in Nashville. And what they returned to the issuing magistrate was just a simple return that said, "We seized the truck." That's all it said. Now, the warrant itself did not authorize that. It just authorized a search of it. And what it certainly didn't authorize was it did not authorize the officers to take individual items from the truck, send them to a lab at the TBI, have them tested, and which is, again, far more invasive than just a basic search, and then use that information, what they get from that subsequent test, to gather evidence against Ms. Kilgore. So what we're asking the court today to do is say, there is a way to do this. There is a way that the officers could have done what they were attempting to do. But when the warrant says you are authorized to do this limited thing, the warrant means what it says. And if the officers exceed the scope of that warrant, then anything in excess of that warrant is a violation of both Rule 41 and the statutory guidance on how warrants are meant to be executed. So in that sense, we're asking the court to find that the trial court erred when it denied the motion to suppress any evidence that was in excess of what the warrant or what the warrant authorized officers to do. Secondly, I guess I'll just mention one issue that it appears the state has conceded, and that is there should have been a merger of the theft and especially aggravated robbery convictions. Again, because the state has apparently conceded that issue, I think it does not merit much discussion other than to say we'd ask the court to accept that concession and reverse that limited conviction. Finally, I'd like to discuss sentencing. What the trial judge did here was sentence Ms. Kilgore, who at the time of sentencing was in her mid-50s, what is effectively a life plus 80-year sentence. This is for anyone, and certainly would be for someone in their mid-50s, a sentence of life without parole. I don't think it can be reasonably disputed that that's what the sentence effectively is. And the problem with that is, there are a number of problems with that, but first and foremost, what I'd like to focus on is there is a statutory procedure for imposing a life without parole sentence. It involves certain notices in advance, and it involves going to the jury and having the jury return that conviction and return that sentence. Maybe they would have in this case. We'll never know. But what we've done, or what the state's effectively done in this case instead, is just replace the jury with the trial judge to get the same result. And that result is a life without parole sentence. And that was done without any real discussion by the sentencing judge about the rationale for that, again, life plus 80 sentence. A couple other problems with the sentence that I'd like to mention. One of the sentences that was ordered consecutive, we don't even know what it is exactly. There's a federal sentence that's hanging out there, and it was just kind of tacked on at the end of the sentencing judge's conclusions of that's also.
I wanted to ask you, Mr. Ridley, have the federal sentences that were aligned consecutively with these sentences, have the federal sentences been imposed yet?
The last time I checked, they had not been. I don't think there was any movement to even do that at the federal level.
So the sentencing order in our case provides for these sentences to run consecutively to sentences that are unknown at this point. Is that right?
Yes, and that, Your Honor, is my problem with the sentence. It's kind of a contingent sentence where we don't actually know what the contingency is or will be. The federal government might move with it, they might not. We don't really know. But what we do know is that right now, if you were trying to calculate what Ms. Kilgore's actual sentence is, you wouldn't be able to do it because one of the variables is unknown. And
Mr. Ridley?
Yes,
Is
Your
the
Honor.
federal sentence related? Do we know anything about the federal case?
Yes, Your Honor. It is entirely unrelated to this. Ms. Kilgore had a conviction for a bank robbery, in essence, several years back, where she served some time and it's been released. But that's what it is stemming from. But the point is really that this winds up or ends up affecting the total length of the sentence, but we don't actually know what it is. And so when a trial judge or a sentencing judge does a sentence that, again, is effectively a life without parole sentence and includes within it a sentence where we don't even know what it is, that's not really in keeping with the purposes and principles of sentencing and rises to the level of abuse of discretion, even under Bias or even under Pollard, I suppose. Because
let me ask you this: what if the judge had said nothing? What was her sentence?
Well, generally speaking, when there's silence as to sentencing, concurrent is the default rule. And if you're going to go in excess of that with a consecutive sentence, you would have to be explicit about that. So in the absence of something explicit, I think we would just assume concurrent.
Mr. Ridley, I've written several times, there's no way you can make a sentence concurrent with a federal sentence in the state of.
I agree with that, in that a state court doesn't really have any authority to affect a federal sentence in any way. But what I took the trial judge to be doing was just kind of throwing this on top of whatever state sentence there would be. So I agree that at a certain level, a state court judge doesn't have any authority to tell the federal government what or how a sentence is going to work, if one thing is going to be calculated at the same time as another. But that's not what the judge did here. The judge here said this is going to be consecutive. And the problem is we don't know what it is. So maybe
we know what his sentence is. We know what the state sentence is.
I suppose we know what it is if you omit the federal sentence from the calculation.
And we know we can't control what the federal government does, whether the federal government leaves that prisoner in our custody or takes it into theirs.
That is correct.
So it's irrelevant what the judge said in that regard, is it not? And even in keeping with our own sentencing guidelines, the judge was only placing a sentence on or calling it consecutive because this particular defendant was on probation or parole when they committed the other offense.
Oh, okay. I'm not sure I'm following the question at the end of that.
Well, in other words, if it was a state offense that was this same offense had occurred in Shelby County, the judge was well within his purview or her purview to give this sentence a consecutive consideration.
Oh, had this been a state sentence and the trial judge had wanted to impose consecutive sentencing on the basis that Ms. Kilgore was on probation for it, I certainly think that would have been within the trial judge's authority. But that brings us to another issue with the sentence that again relates to the effectively LWOP nature of the sentence. At a certain point when you're stacking sentence upon sentence upon sentence and you get to a total number that's completely incommensurate with the lifespan of anyone, let alone a 50-year-old woman, there stops being a point at which it's commensurate with the overall offense or offenses. And when it's not that itself can be a violation of Buys and Pollard, where you have to be able to say, is a 150-year sentence or a 130-year sentence, I suppose it would be in this case, is that consistent or commensurate with the offenses that she actually committed, when what we know is that means she's going to die in prison. We know that as a result of this sentence. And is that something that the trial judge can do without making more findings that that's a necessary element of punishment for these particular offenses? In this case, the trial judge didn't make those findings. The trial judge never said it is important that this sentence be so long that we are ensured that she will die in prison because these offenses are that bad. There were never any findings of that nature. And without those, I don't think we can say that Buys and Pollard are so broad that they authorize a trial judge to impose a sentence of, if we're taking it literally, it could have been a 300-year sentence and it would have made no difference in the eyes of Buys and Pollard. And I don't think Buys and Pollard are that broad. So you have a defendant, Jamie Ellison Rouse, which was 18 years old and had a school shooting in Richland in 1993 or thereabouts. He's serving 2 life terms without possibility of parole plus 46 years. And the finding of the trial court had to be for the 46 years was that he proposed a threat to the community. Now, if he's dead twice, it's illogical that he could provide a threat to the community. But the Supreme Court has routinely not reversed those type of sentences because it would depreciate the fact that there were other sentences involved. There were other crimes involved. So what you're asking is, once we get to a certain number, 51 or 39 or whatever the age of the defendant is, that they're more likely than not to die in prison. Whatever other crimes they get a free pass on because they can't, they're not going to be required to serve those. I don't think the Supreme Court is going that way. That may very well be right. Nevertheless, when you say more likely than not won't survive that long, we're way past the point of more likely than not. She will not live this long. Absent a miracle of miracles in the world of science, that's just not going to happen. So it's certainly not a more likely than not won't live that long. It's a she is not going to live that long. And again, the case that's cited in the brief is Biggs. At a certain point, we have to say this is commensurate with the actual offenses committed. So we have to be able to say this murder, if the conviction itself stands, coupled with the other convictions that came with it, is so bad that it justifies a sentence that is effectively double what another person might get for the exact same offense, depending on the jurisdiction where they're from. And if you're going to do that, and if the case Your Honor mentions, if a judge is going to do that in a case like that, there need to be findings by the trial judge or by the sentencing judge that support such a lengthy sentence. And I don't think we have that in this case. And I think one way you can see that we don't have this is the federal sentence that we were just discussing, where the federal sentence is just kind of tacked on haphazard without any real discussion of, well, let's just throw in an extra 10 years from the federal sentence that may or may not be applicable. We don't really know, but we're just kind of throwing it on without any real discussion of how that is justified in relation to the offenses actually committed. So the problem ultimately, as it pretty much always is in a sentencing case when we're dealing with Bias and Pollard, is a trial judge has virtually unlimited authority to sentence the defendant however they want under those two cases. But it is contingent upon findings. It's a contingent upon the discussion about why that sentence is necessary. And I don't think we have that in this case. And
Well, if he was sentencing to the minimum of certain crimes, why would he have to put anything on the record?
Well, I mean, the problem in this case is the consecutive sentencing, not the total amount for each individual sentence. I mean, if he had just done the basic life imprisonment for the first-degree murder conviction and everything else was concurrent, it wouldn't really matter what the total number for those other sentences would be. It's just that they're consecutive, and that's the problem.
Okay.
But those are the three issues I wanted to discuss today. So we have the search warrant issue where, again, we're just talking about exceeding the scope of what the warrant actually authorized, the merger issue, again, which I believe the state's conceded, and the ultimate total sentence, which at a certain level is just purely incommensurate with the offenses actually committed and is effectively a life without parole sentence without the state following the necessary things to achieve that sort of sentence. So for those reasons, we'd ask the court, and those reasons, in addition to the other ones discussed in the brief, we'd ask the court to reverse.
All right, thank you.
Thank you.
General Smith?
Good afternoon, Your Honors. May it please the court, Colleen Smith on behalf of the state.
Let me ask you just right off the bat while it's fresh on my mind. If you have two different courts sentencing a defendant 2 different times, shouldn't it be up to the second court to decide whether those sentences run consecutively or concurrently and not the first court?
Well, what's prohibited is the state can't tell the federal government how to run its sentences, but they didn't do that here. And I've cited to Bragg, which upheld exactly this kind of situation where our court is free to say that regardless of what the federal government does, we're going to stack this particular sentence consecutively to whatever the federal government does, but we're not telling them what to do. And I think that's what we have to.
General Smith, how can we do that?
How can we order it?
You're telling me or offering me that we can do this sentence consecutively or make them do it consecutively?
No, we cannot make them do anything. And I think the court didn't, in the court's order, it did not direct what the federal government should do with their sentence. And that's what I'm trying to say is we didn't tell
but if under our own code, the concept of alignment of sentences presupposes that the court is adjudicating what to do about 2 different sentences. In this situation, we don't have 2 different sentences. We have our sentences, and that's the only one. We don't have federal sentences to even talk about, right?
Well, what the court was talking about, and my understanding of what was going on with that federal possibility of the probation revocation, and I may have misunderstood this incorrectly, but my understanding was it was based upon her crimes in this case. So should her federal probation be revoked as a result of the crimes in this case, the court here said we're stacking this particular sentence consecutively to whatever sentence she might receive federally for violating her probation.
Well, General, what would be the best practice for the trial judge to do in this situation? Since he doesn't have any control over the federal government whatsoever, why not just pronounce his sentences and leave the federal government out of it altogether?
Well, that might have been clear. I'm not going to advocate that this is a best practice, but I do think that the court was authorized to do it. And like I said, I did find a case, Bragg, that I've cited to in my brief where this has been upheld. So I don't think it's completely disallowed. But as far as best practices, I'm certainly not going to advocate that that is the best practice, but I don't think it's any basis for reversal. I can address the sentencing issue now since we've kind of started that way, and then I'll kind of circle back to the search warrant. So with regard to consecutive sentencing, the court found that that was appropriate for 3 reasons. First, the court found that the defendant had an extensive criminal record. She had prior federal convictions of being a felon in possession of a firearm, attempted bank robbery, and possessing a firearm in relation to a violent crime. She also had prior convictions of aggravated robbery and aggravated assault, and she doesn't challenge her criminal history. So on this basis alone, this is sufficient to support consecutive sentencing. Nor does she dispute that she was on federal probation at the time she committed these crimes, which would also on its own be sufficient to support consecutive sentencing. Because I have those, I'm not going to belabor the point that the court's finding that her behavior indicated little or no regard for human life was also proper. The defendant argues that the court failed to make the additional Wilkerson findings about reasonably relating to the severity of the offense. Yet a court is required to make those additional findings when it imposes consecutive sentencing solely upon a finding that a defendant is a dangerous offender. That's not required here since we have multiple reasons supporting consecutive sentencing. And with regard to her argument that the court abused its discretion by failing to find that the total effective sentence was commensurate with her offenses, she relies on Biggs, but that's entirely distinguishable as the court in that case found that the defendant had used a toy gun. Nobody was hurt. The defendant in that case had no prior offenses. Clearly, that is not what we have here. The concern in Biggs that the sentence was too great for the crimes is inapplicable here. Rather, the court placed many reasons on the record for entering partial consecutive sentencing, all of which were supported. There was no abuse of discretion. If there are no further questions about consecutive sentencing, I will circle back to the search warrant issue. The defendant's argument that the police exceeded the scope of the search warrant is unsupported. Beginning with her claim that Tennessee Rule of Criminal Procedure 41C3 would be rendered meaningless if police were permitted to seize an item because they're allowed to search for it, we're talking about DNA evidence and other trace evidence here that necessarily must be seized in order to conduct a search, as well as other physical evidence. Just some of what the warrant in this case specifically authorized the officers to search for included any blood, hair, fiber, DNA, trace transfer evidence. There was also cell phones, firearms, financial records, clothing with blood splatter, anything associated with the murder or covering up the murder. The defendant hasn't explained or identified any precedent to show that officers were prevented from seizing samples of bloodstains found in the truck, or the guns that were stolen, or the bloody shirt, or the lighter fluid that was used in the murder. Any of the physical evidence, all of which was specified by the warrant. This argument is totally unworkable and unsupported. The rule requires a warrant to name or describe the property sought, and it did that here. And she also argues that the police exceeded the scope of the warrant by seizing her vehicle for TBI testing. She argues that the warrant only permitted them to search her truck for certain items and not to seize it. And that they weren't allowed to send it to the TBI for testing. Again, this is totally illogical. The warrant specifically directed officers to search for trace evidence such as DNA, fibers, blood, hair. She ignores the obvious futility of obtaining DNA evidence without the ability to test it in a lab. There's no authority to support this unrealistic argument. And her argument that the fact that the detective supplemented the return of the warrant after the TBI issued its forensic reports, she's saying that shows they did more than what the warrant contemplated, but she acknowledges that the police conducted the initial search within the appropriate time, and she's trying to shoehorn in the time it takes to conduct DNA testing into the general requirement that searches happen within 5 days of the warrant being issued. She ignores that such testing and reporting takes longer than 5 days. This argument is totally impractical. There's no such requirement. And I've cited to Melton in my brief, which holds that we need to take a common sense approach in this type of situation. And I've also cited to NASMA, which is a case out of California. It's very persuasive, in which the court addressed exactly the situation that we have here and concluded that a vehicle cannot be properly searched without being seized and taking it to the crime lab, and that this doesn't offend the Fourth Amendment. The court noted that the state would not have all the scientific equipment on hand in the field. And even if this court disagrees, the trial court properly held that the good faith exception would apply in any event. Detective Johnson included details of precisely what he wanted to search for in his affidavit. He seized the truck when the defendant was arrested, looked through it before moving it, secured the firearms that were in the bed, and sent it to the TBI for processing the very next day. And if that's not enough, the search would still be proper under the automobile exception. The defendant doesn't dispute the existence of probable cause. And given the plethora of evidence that we have in this case, police clearly had probable cause to seize her truck. And if there are no further questions, I believe I'll not discuss merger since we've conceded that. And I don't believe we've discussed sufficiency today unless your honors have any questions about it. I will just rest on my brief for a discussion of sufficiency. Thank you.
Thank you. Rebuttal?
Yes, Your Honor. I guess I'll start with the state complains that it would be impractical to require the search warrant or require the officers to execute the search warrant in accordance with the terms of the warrant itself. Now, everything the general is saying about what the officers could have done is undisputed. I certainly agree that had the warrant authorized everything that the general is advocating for, the officers could have done it. And there might have even been probable cause for that. That's not what the warrant said. What the warrant said was you can do a limited thing. And what the officers did went far beyond that. So all of the practical concerns that the general is raising could have been addressed. They could have asked for a specific type of warrant that included everything they wanted to do. And if that included exceeding the 5 days to conduct additional testing, they could have asked for that. And I imagine that the magistrate almost certainly would have approved it, but they didn't ask for that. What they asked for was a limited thing, and they exceeded the limited thing they asked for. That's where the problem is. Not the practicalities of how you do this, because you certainly can do it. But if you're going to do it, you have to ask for it, and the warrant has to approve it. The state can't just come in and say, well, we asked for a limited thing, but obviously we meant something much more than that. If they meant something much more than that, they could have asked for it. They didn't, and that's why suppression was required. I guess I just had one follow-up thing on the sentencing issue, just as a matter of clarity. I'm pretty sure what's happened here is the federal sentence that we're talking about now is a potential revocation of probation, and the probation that we're talking about is from the bank robbery. So it's not a new sentence, but it does arise from this series of crimes, and that the probation is being revoked or potentially being revoked because of these new state charges. So it's kind of sort of related to this new set of charges, but the original probation itself was from a prior event. So I just wanted to make sure that was clear for your honors before we got too much further. But other than that, again, we just asked that the court take a look at the sentence, take a look at the search warrant and other issues that are raised in the brief, and reverse these convictions and or the sentence. And that's all I have.
All right, thank you. The court appreciates counsel's arguments today, and that does conclude the argument in this case.
This court is now in recess until 2 p.m.